were discussing this before we started. A lot of people, when Troxel came out, believed Troxel to be a grandparent rights case, but in fact, it was a parents' rights case. So Troxel v. Granville came out of the U.S. Supreme Court. It was a case involving a grandparent whose child, the parent of the grandchild, had died. And the other parent of the child was denying the grandparent access. So the grandparent sued for access to the child. And leaving out a lot of the irrelevant parts of Troxel, what's relevant to this discussion is that Troxel very heavily upheld the constitutional right of a parent to parent their child. And so what the takeaway for this discussion is from Troxel is that a parent has a constitutional right. So we know that that's a right that's like way above just a regular right. I mean, this is like a huge, serious right that a parent has to parent a child without interference from the government. Government interference comes whenever, theoretically speaking, whenever a court orders a parent to do something that the parent does not think is in the child's best interest. Now, we obviously know that a court or a government can intervene in a parenting relationship if there's danger to the child, CPS type situations. But in a situation where the parent is basically a fit parent, doing a decent job, there's no child abuse going on, how does a government unit, a court, intervene in the parent relationship and say, Mr. Parent, Miss Parent, you must allow this grandparent access to your child on the first 35th weekends of a month or whatever? So Troxel stands for that proposition that there has to be some proof that the parent is not a fit parent in order to intervene in that relationship. So for the non-parent, the next step in the analysis is proving that the parent is not a fit parent, which again is a very high hurdle. I mean, you would hope that all the parents are being fit parents. Now, in that analysis, it's not good enough to prove that the child would suffer due to the lack of relationship with the non-parent. That's not enough. A lot of the grandparent cases out there that are kind of going through the same analysis say, you know, but I'm the grandparent and the child will suffer if she doesn't have a relationship with me. That's not enough. M. Ray Scheller out of the Texas Supreme Court says that's not enough. You have to prove that there is some problem with the parenting of the biological parent. So if you rebut that presumption, and only if you rebut that presumption, does the non-parent then move to the question of should there be conservatorship? Should there be access to the child for the non-parent? If you fail in proving or in overcoming the parental presumption, then you fail at obtaining custody. There was a case, if some of you are involved in you know, the LGBT community in Dallas, there was a case of, maybe a year ago, right around Christmas a year ago. Not one I was involved in, I hope you weren't, but
I'll let you know.
happy. Very sad situation where a non-parent sued for access to a child when she and her partner broke up. She overcame the standing question. And unfortunately, the judge that was the judge of that court at the time disagreed with my analysis. My analysis is that it is a three-step process, kind of like proving up a common law marriage. It's a three-step process. You first have to prove standing. Then, in my opinion, there has to be a hearing to overcome the parental presumption. And then there has to be a separate hearing to overcome or to go through the best interest standard on whether there's conservatorship. That judge disagreed with my analysis. Not that I was involved in the case, but he and I had a specific discussion. And he felt that the parental presumption and the best interest question should be tried together. So he proceeded with a trial where The non-parent was forced to both overcome the parental presumption and show the best interest factors to obtain conservatorship. At the end, it was a jury trial, and at the end of the jury trial, she lost. And it was a very emotional loss for her. And unfortunately, a few days later, she committed suicide. And it was in the Dallas Voice pretty prominently. And no doubt, I mean, how horrible for her to have been awarded standing and to be allowed access to the courtroom, only to be turned away by a jury of Dallas County citizens who said, I'm sorry you didn't overcome the parental presumption well enough to get custody. It was horrible for her, I know. I mean, I didn't know her, but we can all empathize with that. And so she, the Dallas Voice wrote a lot about her plight and fortunately invited me to be a part of that conversation. But that to me kind of goes back to what David's been talking about. And the message I give to people whenever they contact me soon enough in the ball game before everybody's unhappy with each other is if y'all intend to parent this kiddo together, get down there and adopt while everybody's happy. Because if you don't, it's going to be too late. And it's going to be almost impossible to overcome all of the hurdles that an emotional parent, granted, but non-parent legally, has to overcome to get to the point of having court-ordered access over the objection of the parent.
So I'm going to pose to you the same question that our esteemed professor posed to the class the other day, because I love the fact pattern that Justice Thomas gave us with a little bit of a twist. Larry comes to you for help. Our friend Larry, who's over there laughing at me. His partner's name is John. Larry comes home to find himself locked out of his house, so you're going to be calling Keith, right, for that. And after visiting for some time, you've learned that he and his partner John have lived here for 3 years. They used to live in Massachusetts, and while they were in Massachusetts, they got married legally 5 years ago. When they moved here, Larry gave up his lucrative career and decided to be the stay-at-home dad to the 2 kids. But the 2 kids are not his biological children. They're John's bio kids. And these children don't have a mother anymore. When they were very young infants, their mother died. So we're not worrying about mom. All their life, they've known Larry to be a parent. But they never got formally adopted. Larry never formally adopted him. So now he's cut off from the kids, and he hasn't seen the kids for almost 3 months. And he comes to you, so there's timing there. What would you tell him about his hopes for that shared custody?
Well,
Walking through all of that?
yeah, no, not at all. I'm actually a believer in being a realist for my clients and potential clients. I don't sugarcoat things, and maybe I'm a little more honest sometimes than I should be. But
I'll vouch for that, by the way.
hey. So yeah, I mean, I would tell him first of all that if we're going to do anything, we've got to do it fast before that 90 days passes, or he's SOL forever and ever. But beyond that, I would ask him, you know, what are the other parents, the biological parents' positive and negative qualities? If he couldn't come up with enough that I felt like would actually overcome the parental presumption, then I would tell him basically that I didn't feel that he had a good case, and that I'd be willing to take it and litigate it if he has the money. Honey, I got the time, but that I don't want him to have unrealistic expectations.
Okay, so what kind of things would you be wanting to hear? What would be juicy enough for you to say? And I'm not talking about awful. You watch the porn or something like that, create fun of kids. Boom, that's an easy one to prove unfit parenting. We've got John that's just traveling. He's a heavy worker. He's the sole breadwinner. He's gone a lot. How heavy does that weigh on the?
I don't think that would get you there. I mean,
He's a great financial provider, but that's about it. He's not emotional. He doesn't spend a lot of time
that's
with
not
kids.
enough. The family code says that you have to show that the biological parent appointed as conservator would significantly impair the child's physical health or emotional development. Significantly.
Okay.
To me, that rises above the level of a normal custody case. To me, that rises to the level of